Friends, it is a common procedure under GST to issue summons under Section 70 of the CGST Act 2017. In this release, we are going to discuss the rights and obligations of the taxpayer in these summons. So, Section 70 of the CGST Act empowers the proper officer, maybe DGGI or maybe the jurisdictional officer or anti-evasion officer or any proper officer under the CGST Act to compel the person or the taxpayer to produce evidence, information, document or thing, and the procedure under the Civil Procedure Code would be followed, and such inquiry or summon would be judicial proceedings under the Indian Penal Code, and the taxpayer could be penalized for giving false evidences or for not appearing or for creating hindrances in such summons under 228 of the Indian Penal Code. So, a common question which is asked is how the summon should be served, and it has been held by the apex court that a summon should be properly served. And while the suo motu order dated July 2020 very recently, the apex court has held that summons or notices can be served through email or even through WhatsApp followed by the email. Therefore, it is very important for taxpayers to provide the correct email ID to the GST or the income tax or any other tax authorities, because summons or notices can be issued via email and even through WhatsApp. So, the mobile number which is provided to GST or income tax should also be of the correct person. Another question which is asked is, can COVID-19 be a ground of not attending summons? Friends, in this context, my humble legal submission is that it has been held in the case of P.V. Rao versus Senior Intelligence Officer DGGI by the Delhi High Court that COVID-19 cannot be a ground for not attending the summon. Yes, it may be a ground in case supported by corroborative evidences to possibly seek an extension, but it cannot be a ground to refuse to attend summons. Another question which is commonly asked is whether the presence of a lawyer can be enforced during summons. Well, friends, it has been held by the apex court in the case of Pul Pandi and also reiterated by the Delhi High Court in the case of Sudhir Kumar Agarwal that the instant proceedings under the GST Act under Section 70 of summons, the officer is not a police officer, he is just a revenue officer, and the presence of a lawyer during the summons in the summon room may be denied until and unless an exceptional circumstance exists. The other question many a times is asked is whether the jurisdiction of the DGGI is encompassed in the entire country. That is, even though your local office or place of business is in, say, Chhattisgarh or West Bengal, can the DGGI summon a taxpayer to Delhi outside his local jurisdiction? Well, friend, in the case of Sri Ravi Agarwal versus DGGI, it was upheld by the Chhattisgarh High Court that the jurisdiction of the DGGI encompasses the entire country and the DGGI can summon a person to Delhi, which is its headquarters. Well, another question which is asked many a times, it is common that once a taxpayer is called for summon, and in case the commissioner has a sufficient reason to believe that there is a manipulation for the purpose of evasion of tax, to invoke section 69 and section 132 of the CGST Act with respect to prosecution or detention of the taxpayer. The question which is asked is whether the commissioner has the power for detention under 69 and 132 of the CGST Act without conducting an assessment under 73 or recovery proceedings under 73 or 74. It has been held by the Honorable Gujarat High Court in the case of Vimal Yashwant Giri Goswami that in case the commissioner has a sufficient reason to believe that there is a contravention or manipulation with the intention of evasion of tax, then a detention is possible even without invocation of recovery proceedings under 73 and 74. Well, friends, many a times it is seen that there is an enforcement for deposit of certain sum of money as determined by the DGGI or the revenue officers. Well, a question which is asked is whether without a proper assessment such a demand for deposit is as per the law. In this regard, our legal submission is that it has been held in the case of Rishi Bansal versus the revenue by the Delhi High Court that without a proper assessment, a deposit or a compulsion to deposit a sum of money was not regular as per the GST Act. The same has been held in the case of Pardeep versus Commissioner of GST by the Honorable Apex Court in 2019. In the instant case, the determination of the tax amount was rupees 20 crores by the proper officer without an assessment. It was held by the Honorable Apex Court in the case of Pardeep versus Union of India that at the maximum, the taxpayer has a constitutional right to appeal against such determination, and in case the taxpayer goes for an appeal, the maximum liability for pre-deposit is 10%, and therefore even if the maximum amount is determined as 20 crores, a amount of rupee not more than 10%, that is rupees 2 crores, could be asked to be deposited by the taxpayer. Well, friend, another legal issue is whether a detention during summons can happen for long hours. In the case of Roshan BV versus Joint Secretary, it is a matter in the Customs Act where the instant assessee was held back for more than 24 hours and he was called for summons at odd hours at night. It was held by the Honorable Court that detention for more than 24 hours or call of summons during odd hours at midnight or detention during midnight is violative of Article 22, sub-article 2 of the Indian Constitution, and therefore detention during summons or calling of summons during long hours would not be as per the constitution of the country. Another very important right of a taxpayer during a summon is to get his statement recorded voluntarily, that is without any coercion or force. Well, in case there is any coercion or force, then such recording of statement can be retracted in future under the shelter of coercion or force. And last is, many taxpayers are afraid of use of violence, including a mental violence like abusive language or threat of violence, not only against the person being summoned but even any other person interested in the matter. Well, it is very clearly held by the apex court and various high courts under GST and erstwhile taxation regimes and income tax also, that even mental violence or use of untoward language cannot be attested by the courts and the violence cannot be used during a summon. So friends, there are various rulings, as we have discussed in our legal submissions, which guarantee rights under the Constitution of India to the taxpayers under GST. However, there are various obligations of the taxpayers also, and the taxpayers should be knowledgeable about not only their obligations but even the rights, so that the summons can be seamlessly encompassed in GST, and there should be no fear when one is regularly complying with all the provisions of the GST law. It is very important in GST, as we have been saying in our earlier submissions, that there would be a concurrent assessments, there would be concurrent scrutinies under GST. So it is very important to be fully compliant under GST, to file your returns of time, so that there would not be any rigors of the law under GST. Thank you very much.